Item number 1. Yes, please.
Your Lordship, I'm appearing on behalf of respondent number 6, Your Lordship. The contending counsel, Your Lordship, could not be appeared today due to personal difficulties, Your Lordship.
We are specially sitting for this matter. The appeal is, Mr. Deputy Solicitor General is ready for hearing.
But the matter was listed on several occasions, my lord. Not been admitted since. Because what is happening, my lord, since the time it is filed, because there are many respondents, my lord. On some dates, some respondents are present. On some dates, some other respondents are present.
No, but what is the status of the matter? Admission stage, hearing stage?
It's not. It doesn't say that there is no order of admission, my lord.
You are for the appellant.
I'm for the appellant, my lord.
The respondents have been served.
They will serve. They appeared, my lord. Lots of kindly sees last. The district council is represented by Mr. T.T. Dingdo, senior advocate, my lord. Mr. Sangreso is for some of the respondents, my lord. Miss N.G. Sila is for some of the respondents. It appears that none of the respondents are present today, my lord.
For filing objections. Objections to what? In an appeal?
You will not file any objection, Your Lordship, in this matter. You will not file any objection, Your Lordship. You have to, according to the order of 14/5/2024, Your Lordship, you have stated that.
My lord, may pray, the date is fixed. I'll inform all the councils, my lord. Because there are 3 parties respondents, my lord. District Council, respondent number 5 and respondent number 6.
This is an appeal from an order passed in a writ.
My lord.
So what is the, please come to this 14/5/2024 order for filing objections to what? Is there any stay application?
No, my lord. My lord, then subsequent order also will see when the matter is taken up for hearing, it is represented by the 6th respondent that it will not file any objection.
Objection what? What is the scope of any objection?
My lord, next order, then again they said that they are not filing, my lord. The order of 13/6, Lord, you kindly see.
Cross objection. Do you mean cross objection?
Yes, Your Lordship.
You have not filed cross objection.
Lordship, you will not file any more, Your Lordship.
Speak a little louder, please.
You will not file any more, Your Lordship, the objection.
What is the nature of this order? Impugned order.
But the impugned order here, what happened, my lord, in Shillong, in East Khasis, my lord, there are CMs. There was a traditional chief of, there are 25 CMs, my lord, in the East Khasis district. So they are customary head or chief, my lord. Now the petitioner was one of them, my lord. He was suspended, my lord, from his office. So against that, we have come before this honorable court, my lord. Our case is that there was a violation of certain rules in suspending, my lord. And
Are you pressing for any interim order in the appeal?
but I'm not pressing for an interim order because it's quite some time, my lord. The order was passed since 5th of December 23.
We admit this appeal from a judgment and order of a learned single judge of this court in the exercise of his writ jurisdiction. Full stop. It appears from the records that this appeal has been listed from time to time, and the respondents have entered appearance
Yes.
in court. Paragraph. Therefore, dispensing with all formalities, we expedite hearing of this appeal. Next, advocate on record for the appellant will file an informal paper book in this court by 13th March, serving a copy thereof on each of the respondents or their advocate on record. Each of the respondents or his advocate on record at least 1 week before the date fixed for hearing of the appeal. Paragraph. List this appeal for hearing on 26th March. 26th March, है ना?
For 26 more, those matters are fixed, my lord.
Oh, I see.
Can be sometime the first week of April.
All right. On 3rd April.
Well, keep.
Item number 2.
Yes.
Lord, on the last date of hearing, I had concluded my arguments. The respondent had to begin his arguments. This was the matter on interest, that whether interest can be awarded. My Lord, I had just one thing before my learned respondent starts. My Lord, there were 2 arguments I had taken. One was on the aspect of whether the clause being relied upon by them allows interest to be taken. And the second was a principle of waiver, that since they have not argued this before the learned arbitral tribunal or the 34 court, is that clause waived? My Lord, I had raised certain questions about it. I had researched, and my Lord, I would want to give up my first point, which is the clause, that whether the clause permits interest or not. I would like to stick only on waiver. So just to make it convenient for the court, I don't want to labor on something that there is law against me. So I want to be fair to the court.
See if there is any notebook. Any note was taken. Previous hearing, any note was taken. Sure. Yes.
Yes. So, my Lord, like I said, there were 2 arguments being taken. Should I refresh my arguments, my Lord?
Please, please.
Yes. Yes, I'll do that. My Lord, this matter pertains to a work order issued by the respondent by way of a tender for construction of the auxiliary building of their power plant. That
Yes.
work order was issued on 23rd May 1996.
No, you come to that law point about
Correct.
it. Yes.
So, my Lord, subsequently an award was passed in my favor.
Yes.
I was awarded pre-suit interest, pendentalite interest, and post-award interest. That, as the award in toto, was challenged by the respondent in a 34 petition, which came to be dismissed, except on the limited aspect of interest. So far as post-award interest is concerned, The learned 34 court was kind enough to dismiss the petition qua the same, but so far as anything before the what, which is the pre-suit and the pendente light, the learned 34 court held against me and set that interest aside, relying on clause 31(7)(a) and certain Supreme Court judgments. Now, aggrieved by that aspect, I have filed this 37 petition, and I had argued two different points, my lord. The first point was that the clause they're relying upon, they did not rely upon it during the Section 11 petition or the entire arbitration proceeding, neither in their counterclaim, neither in their reply, neither in their evidence, nor their written submissions. So, having not done that, they have waived that right to argue agitated before the 34 court. Even in the 34 petition, my lord, I would say that in all the claims, they have not, there were 4 claims, my lord. Out of 4 claims, 2 of them, they have again not agitated this point of interest. In the remaining 2, they have just said it is against the contract. They are still not specific which clause in the contract is it violating. It is only at the stage of final arguments that they read that clause before the court, 34 court, and got an order in their favor. They relied on a judgment of the Honorable Supreme Court, my lord. On the last date, I had given a copy to my lords by the name of Union of India versus Susaka, which was tailor-made for this case, my lord. Identical facts. My lord, have a copy? Should I provide another copy? Because last week we had given a copy, my lord. And my lord had marked the copy as well, if I remember.
You ask your junior to come here and help the officer.
Yes. एक ही है. ठीक है. चलें. Note also जा सकती है. एक कॉपी तो है हमारे पास. एक ही कॉपी है.
For his lordship.
Yes, sir. Actually, before reading Susaka, my lord, I can show the relevant clause in the Arbitration Act to assist the Honorable Court. My lord, may look at section 31, subclause 7, which refers to interest on an award.
Arbitration Act.
My lords have it. Section 31.
This was relied upon by the learned judge.
Yes,
Section
my lord.
34.
31, my lord.
Section 31, not
31, subclause 7. The 34 court relied on section 31, subclause 7, my lord.
Was there any bar in the contract?
My lord, there is a clause that has been interpreted by the Honorable Supreme Court in another judgment to say that there is a bar on interest in this kind of a clause. My lord, can I take you to the relevant part? 31, subclause 7A.
Yes.
Unless otherwise agreed by the parties, where and insofar as an arbitral award is for the payment of money, the arbitral tribunal may include in the sum for which the award is made interest at such rate as it deems reasonable on the whole or any part of the money for the whole or any part of the period between the date of the cause of action arose and the date on which the award is made. So, my lord, this talks about the pre-award interest, date of cause of action till the date of award. And it gives wide discretion to the learned arbitrator, but it says, provided it is, unless something else is agreed by the parties. Now, my lord, subclause B talks about post-award interest. It says, a sum directed to be paid by an arbitral tribunal, arbitral award shall, unless the award otherwise direct, carry interest at the rate of 2% higher than the current rate of interest prevalent on the date of award, from the date of award to the date of payment. So this says that interest has to be there. Either it is mentioned in the award by the learned arbitrator, or it will be the prevalent 2% more than the prevalent interest rate. So far as B is concerned, which is post-award interest, the 34 court has upheld the same, but the court says that there is a clause between the parties which prohibits interest, and therefore I am not going to give you pre-award interest, and I'm setting that part aside.
Yes.
Yes, my lord. Now, my lord, can come to the judgment I was referring to, which is Susaka, Union of India versus Messrs. Susaka Private Limited. My lords have it?
Yes.
My lord, the third paragraph itself, on the first page. In short, the question which arises for consideration in this appeal is whether the arbitral tribunal was justified in awarding interest on various claims for different periods of the claimant, namely for pre-reference period, 2 for period for pendentolite, and 3 post-reference till payment. So, my lord, identical question which is there before my lords was put before this court in before the Honorable Supreme Court in this matter. Now, my lord, may come to paragraph 6. The High Court, by order dated 27 July, my lord, have that paragraph?
Yes.
With consent of both the parties, allowed respondent number 1 application and referred the various claims 1 to 17 made by the respondent claimant. Now, my lord, may come to the page number 435 on the table.
Yes.
There is a reference to the pre-reference interest in the table. So there was a reference made by the section 11 code, qua pre-reference. Paragraph 9 now. The single judge by order dated 21st April 2003 allowed the appeal in part and made 2 modifications in the arbitral award with respect to the date of award of interest on the claim of respondent number 1 for damages and the claim of purchase of one item. The single judge made the interest payable from the date of award till the realization. So far as the challenge to other claims, including award of interest on such claims, was concerned, the learned single judge rejected the appellant's objections and upheld the award in totality for all purposes. My lord, paragraph 11. By impugned judgment, the division bench of the High Court allowed respondent number 1's appeal and set aside the order of the single judge. It was held that no ground on 34 had been made out for the Union of India to modify the award to the extent of awarding interest on the claim. In other words, the opinion of the division bench, the grounds on which the limited interference was made by the single judge for setting aside the award in relation to award of interest from a particular date on 2 claims of respondent number 1, there was not a ground falling under 34 of the Act, and therefore the order of single judge was not legally sustainable. It was accordingly set aside, resulting in upholding the entire award and dismissal of the 34 application in its entirety. So, a similar situation happened, my lord. The arbitrator awarded interest, the 34 court set it aside. We are before you. This court,
Please read from paragraph 15.
15. Placing reliance on clause 13.3 of GCC, learned counsel urged that since clause 13.3 provides that no interest will be payable upon the earnest money or the security deposit or amounts payable to the contractor under the contract, except so-and-so, was not entitled to claim interest on any of the heads. In other words, the submission was that the arbitral tribunal misconstructed in awarding interest to respondent number 1 claimant on their various claims when the clause 13.3 of GCC did not allow them to claim any interest on the sums payable under the contract except on government securities if deposited with the appellant. My lord, paragraph 20 now.
Then come to the waiver point.
Yes, my lord. That's para 20. My lord, the reasoning starts from para 20. Yes. On the other hand, we find, my lord, it is not in dispute that the appellant did not raise the plea on 13.3 of GCC against respondent number 1 at any stage of the proceeding. My lord, this is paragraph 20.
Yes.
It is not in dispute that the appellant did not raise any plea based on the clause 13.3 of GCC against respondent number 1 at any stage of the proceedings, either in reply filed before the arbitral tribunal and or in its submission, except raising it for the first time before this court in this appeal. On the other hand, we find that in the section 11 proceedings, the appellant did not raise the objection in the reply and instead gave their express consent to refer the issue of award of interest payable on various claims to the arbitral tribunal, considering the said claim to be arbitrable under the contract.
So issues, thereafter come to that point, issues of facts and law can be waived.
Yes, my lord. Yes, that 23, I'll come to that point, my lord. Okay. If a plea is available, whether on, my lord, this is paragraph 28. If a plea is available, whether on facts or law, it has to be raised by a party at appropriate stage in accordance with law. If not raised and given up with consent, the party would be precluded from raising such a plea at a later stage of the proceedings on the principles of waiver. If permitted to raise, it causes prejudice to the other party. In our opinion, this principle applies to this case.
In the section 34 application,
Yes, my lord.
in this court also there is a provision for grounds, I suppose.
No, my lord, they did not raise this ground.
Grounds are put or
No, the grounds, even the grounds are not put. My lord, in fact, relying on this judgment.
what is the format here? The grounds are there. Just
Yes,
there is
they
an
are.
appeal.
Yes, they are.
So in the ground was challenged.
No. Interest was challenged. The aspect of interest being challenged on this clause was not there.
No. What interest was challenged? Pre-arbitral interest, pendental
My lord, it was a very generic reference at the, so my lord, there was a claim and a counterclaim in the proceedings. They challenged both in the 34 petition. When they challenged it, they challenged on the aspect that when the claim was not maintainable, then the arbitrator should not have awarded interest. But the aspect that there is a specific clause which prohibits interest was not raised by them. So there is a claim-wise ground that has been raised. There are 4 claims. They have not challenged it. They have not challenged it in either of the claims. In one claim, my lord, they have said it is barred by contract. But which clause in the contract? Again, it is silent. But only in one claim out of the 4.
Claim is barred or interest is barred?
So they raise their grounds claim-wise. So every claim they have raised separate grounds in the 34 petition. So each claim.
Their award is against each claim.
Yes, my lord. Yes, my lord.
Then usually the base of the award at the
Yes, my lord.
foot of the award is with regard to interest, followed by cost. Whether the learned arbitrator is awarding cost or not.
That is absolutely right.
So when they've gone claim wise 1, 2, 3, 4, 5, 6, all right.
Correct.
But when they come to the award with regard to interest,
Correct.
then what they have said, that is
So-
usually a separate claim altogether by the.
I understand what is falling from my lord. To answer the question, this is the general format, but in this case, When the claim was made, the claim specifically asked for pendent and pre-suit interest. The claim itself. It was a separate claim was also there for post filing of the petition
That
interest.
is all right. They could not have said that the claim is not entertainable, but the interest is entertainable. They could not have framed their defense in that way.
Correct, my
If you deny the claim, the interest does not follow.
Correct, my lord.
All right.
Correct.
Then when it comes to the interest claim, what they have said?
My lord, can I take you to the relevant page in the
Yes.
pleadings? Yes, my lord.
Because this judgment covers your case.
Absolutely, my lord. Yes.
But the question is that did they waive it?
Yes, my lord. My lord, I've succinctly put it. I'll just take my lord to that. My lord can open the convenience compilation that I had given, volume 1. My lord, before I show their reply, I want to show my claim also so that it's clear how the pleadings have taken place in the matter. Page 26, my lord. How many claims were there? 6. Well, let's have it. Page 26.
Yes.
Well, there were total 8 claims. The first we had withdrawn during the arbitration proceedings. I'm taking my lord straight to claim number 2. So my lord will see in claim 2, page 26. My lord have it. So A is the claim and B is the pre-suit interest on the amount of reimbursement. My lord, see that? Page 26, my lord. Sorry, this.
Which one? Part 2.
Part 2, my lord.
Okay.
Continue the page. Volume 2. Page 26. 26. Not have it? My lord, have page 26?
Yes.
Yes. So, my lord, A, if my lord will see, is the claim. And in B, in claim 2 itself, we have sought for pre-suit interest.
Yes.
My lord, have A and B. Page 26, the bottom of the page, my lord. It starts with the heading claim 2, it is underlined.
Yes.
Yes, so my lord will see in claim 2 itself, we have sought for pre-suit interest. Now, my lord may come to page 32. The first sentence itself, my lord. This is a detailed claim. It says pre-suit interest on the amount of reimbursement at the rate of 15% from the date of so-and-so is for a sum of rupees 1,95 lakhs. My lord, have that?
Yes.
Yes. So, my lord, there is a specific claim by us in our claim petition. Identically in claim 3, claim 4, claim 5, the same thing has been done. My lord, I want to show just one more claim because 3, 4, 5 are identically. Claim 7, which is for the pendental interest. That is on page number 51. Well, let's have page 51.
51.
Yes, my lord, 5-1. This is claim 7. So claim 2 I've shown, my lord. Claim 2, 3, 4, 5 are identically written. So I did not want to burden my lords by showing all the pages. I've come straight to claim 7, which is now for a pendentalite interest. That was pre-suit interest, and now the pendentalite interest is claim 7. Let's have it. Okay.
And in the counter statement, how has it been dealt with?
My lord, in the reply to the claim, my lord may come to page number 140, my lord, of the volume 2. My lord, just to give context, our claim, my lord, have page 140.
Page 140.
140, my lord. So this is the para-wise response to our claim. My lord, have it. Para 2.5. Now, my lord, my claim 2 was para, in claim 2, my para was para 10, where I claimed interest. So their response is a common response for para 9 and 10 of my claim 2. Now, my lord, can see this paragraph, there is not even a mention of denying even interest on this. Forget mentioning a contract or anything like that. The claim, my lord, was on page number 32. If my lord want, my lord can compare and see. 32 and page 140.
How have they dealt with claim 7?
Yes, my lord. My lord, so claim, yes, my lord. I will come to straight to claim 7, my lord. My lord, this is page 176. Let's have page 176. So, my lord, before I read clause 6.1, I wanted to point out one thing. I have already shown, my lords, that for claim 2, 3, 4, 5, which pertains to pre-reference period, they have not even mentioned the contract. Forget the clause. They have not even challenged the fact that interest cannot be awarded as per the contract. In the claims 7, my lord. They have mentioned the contract though, so I'm just showing that. My lord, para 6.1, that in response to the aforesaid claims, my lord, have that?
Yes.
The respondent makes no comment being the question of law, save and except telling that as per the contract agreement, the claimant is not entitled to interest, and in any event, the rate of interest claimed by the claimant is highly excessive. So far as only pendentalite interest, which is 3 years from 2012 to 2015, they have taken an argument that it is barred by contract, but which clause again they're silent. Now, my lord, should I show my lords the 34 petition to see how they have taken the ground in the 34 appeal? Because this is the arbitration proceeding, so they have not taken the ground as I've shown, my lord, in the entire arbitration proceedings. Oh, one more document, my lord, the volume 3. My lord, I realized that by mistake, we had not annexed the written submissions filed by them in the arbitration proceedings. So we have just brought that on record in the informal paper book, volume 3. We had served the other side yesterday itself.
So 34 also. 34 is different.
I do not have anything to show in this volume, my lord. The only reason I've produced is this, my lord, may look at the index. I filed a reply to the section 11. I filed my written submissions before the learned arbitrator, and I've submitted their written submissions. There is no mention of interest by them at all, or denying that interest should not be awarded. Just so that my lords have the pleadings, I have
In the section 34,
in the arbitration record, my lord. This is the arbitration record. Arbitration,
not argued.
not argued. Neither in the pleadings, neither in the written submissions. Now, my lord, relying on Susaka, there are at least 22 judgments which have upheld the law. In fact, my lord, the courts go on to say in a voluminous record, even if they have pleaded, but they don't argue, that point is also considered waiver, because a judge is not expected to look at all the points written by the parties in their pleadings unless they argue it before the court, because only then will the court adjudicate on the same. Now, can I take my lord to the 34 petition and show my lord what they have pleaded?
Yes.
My lord, may look at volume 1 now. Page 33. Let's have it. Para 18. This pertains to claim 2. For the award of rupees so and so and pre-suit interest of so and so from the date of bill till 3rd May 2012 is contrary to the contractual provisions contained under clause 11 of the pre-bid resolution dated 21st July 1995, clause 8 of the work order dated so and so, as well as bid dated 14th August 1995. And as such time, the same is required to be set aside under section 34(2) of the Arbitration Act. The learned arbitrator, while allowing the claim, has acted contrary to the specific stipulations, conditions contained in the agreement between the parties. The arbitrator, being a creature of contract, must operate within the 4 corners of the contract and cannot travel beyond it. And he cannot award any amount which is ruled out or prohibited by the terms of the agreement. In the instant case, the agreement between the parties provided a mechanism to deal with the question of escalation on account of increase in labor, wages, and further prohibited payment of further amount of claim in excess thereof. Section 28(3) mandates the arbitrator to decide in accordance with the terms of the contract. And if he fails to do so, the award is liable to be set aside under section 34. And also no mention of, there's a clause of 54, right? Well, clause 54 is not mentioned in this. Clause 54 is the interest barring clause. They have not mentioned it in claim 2. Now let me look at page number 38 now.
You just have to tell us that they have not challenged.
What I'm trying to
You can't make an argument in the negative.
correct.
You show everything they have pleaded and to say that they have not challenged. You have said they have not challenged.
Correct.
It is for them to show they have.
Yes. Basically, they said this is barred by interest act and other provisions. They have not challenged it so far as clause 54 is concerned. Yes, madam. That's my submission. Madam, claim 3 is identical position.
No, grant of pendentiality interest. Have they challenged or not?
Madam,
Claim 7.
Claim 7, my lord. Yes, I will show that also. Madam, claim 7 they have not even referred to in 34. So they mentioned the contract in the arbitration proceedings, but in 34, not a word or whisper of the claim.
Now give us the authorities where they have said that even if there is a line in the pleadings but not argued in court, the
Yes,
point
madam.
of waiver can be maintained.
On that term, right? Paragraph 11, page 904.
What is the citation?
The citation is 2007 SCR 901. 2007 12 SCR 901.
SCR page
901, my lord. Lord, may come straight to page number 904, para 11. The appellant then submitted that apart from the point that the elected candidate so-and-so was holding an office of profit, the appellant had also raised a large number of other points in the election petition, including the allegation of corrupt practices by so-and-so, but these have not been dealt by the High Court. He submitted that the High Court should have dealt with these points mentioned in the election petition. we have carefully gone through the impugned judgment of the High Court. We find that the only point discussed therein is the point where so-and-so was disqualified because he was holding an office of profit. No other point has been discussed in the aforesaid judgment. Lord, may come to para 14. In this connection, we would like to say that there is a presumption in law that the judge deals with all the points which have been pressed before him. It often happens that a petition or appeal, several points are taken in the memorandum of the petition or appeal, but at the time of arguments only some of the points are pressed. Naturally, a judge will only deal with the points which are pressed before him in the arguments, and it will be presumed that the appellants gave up the other points. Otherwise, he would have dealt with them also. If a point is not mentioned in the judgment of a court, the presumption is the point was never pressed before the learned judge and it was given up. However, there is a rebuttal to the argument, to the presumption. In case the petitioner contends that he had pressed a point also, it is open to him to file an application before the same judge which delivered the impugned judgment, and if he satisfies the judge that the other points are in fact pressed but not dealt with in the impugned judgment, it is open to the concerned court to pass appropriate orders, including an order of review. However, it is not ordinarily open to parties to file an appeal and to seek to argue a point which, if taken in the petition or memorandum appeal before the court below, has not been dealt in the judgment of the court below. The party who has grievance must approach the same court which passed the judgment, and the other points are pressed but not dealt with. Now, my lord, I would like to show some more judgments on this issue.
So if it is replication, you just give us the
Not
citation.
replication, no, just some more judgments. My lord, this is a judgment of the Honorable Madras High Court.
Same proposition.
Not the same identical proposition, my lord. The proposition is my lord, this is that they have not argued the point. This judgment talks about pleaded, not argued by relying on Susaka. Now, para 8. Let's have it.
Yes.
Para 8 says, we have given our anxious consideration to the rival submissions made by the learned senior counsels on either side. Admittedly, the appellant has not raised the grounds now raised in the appeal before the learned single judge. The learned additional Solicitor General, in his reply, made a faint attempt to convince us that the above ground was raised in the grounds of challenge to the award made in the 34 petition before the learned single judge, and the appellant cannot be victimized for the fault of their counsel. We are unable to accept the submission of the learned additional Solicitor General. If this was the case, the proper course would have been to seek leave of the learned single judge to raise further grounds. We also find that the additional Solicitor General did not assail the order of the learned session judge with regard to the two grounds raised by the appellant before the learned single judge during his submission before us. Lord, para 9. We also find that the appellant, by not raising the ground which is raised in the instant appeal before the learned single judge, is precluded from raising the plea in this appeal on the principles of waiver. The relevant portion of the judgment of the Honorable Apex Court in the Union of India vs. Susaka is quoted. Para 10. In view of the settled position of law, we are unable to consider the new grounds raised by the appellant with regard to the alleged infirmity in the findings of the learned arbitrator in rejecting the claim of the appellant. Show me the other Supreme Court judgment.
All right, we got your point.
Yes.
You wish to file notes? You file notes.
Yes, my lord, I'll do that. My lord, there is one judgment that I just would like to show is on vagueness, that they have in their pleadings said it is barred by consent.
Sometimes hammering helps. Sometimes hammering
madam.
has a negative effect.
Very well, madam.
You argued the main points, we have got it.
Only one thing, I'd just like to point out to my lord.
You see, this observation I'm making from the court.
Yes, my lord.
Section 34 of the Civil Procedure Code, you go into it, is not only procedural, it is substantive portion. It is
Section 34
substantive
is-
law.
Yes, my lord, true.
Okay?
Yes, my lord.
Now, Section 34 clothes the court with a power to grant pendentiality interest
And future interest.
and also
Future.
post-litigatory interest. The court is given the power, and pre-suit, the court is to adjudge. Adjudge means read with the Interest Act, whether there is any agreement between the parties, okay, whether under the statute the plaintiff is entitled to interest, etc. But pendentiality interest and future and post-decree interest, the power is with the court. Now, if you read that with 31(7), now 31(7), Civil Procedure Code also applies to arbitration proceedings. 31(7) does not express any express intent to take away that power of the court. That power of the court, the arbitrator also has, under G.C. Roy and other judgments.
Correct.
So that is not intended to be taken away. So that power, which is statutory, cannot be taken away by contract. It would be an illegal contract. So the contract can only deal with pre-arbitral interest, not pendentiality and post, which is the prerogative of the court and the arbitrator. You look into that point. And any other point you have regarding this waiver?
So, waiver, but I would like to show, my lord.
Now, suppose it is held that, all right, under 31(7), under the rulings of the Supreme Court, the parties can agree.
Yes, my lord.
Agree with regard to pendentiality interest also. All right. Now, what is your answer to that waiver point?
My humble submission will be, my lord. In short, I am saying, my lord, I am not showing the details, my lord, also the details of the pleadings and other things. Now, my lord, your lordship will kindly consider one aspect of the matter, that their plea that clause 54 was not specifically pleaded in their statement of defense. I have gone through it. It says that there is a prohibition in the contract, but clause 54 was not specifically pleaded. It is true. But I will show from the materials on record that that plea was there, that it is prohibited by the contract. This is number one. Number two, in 34, also a specific ground has been taken, wherein it has been stated that there is a prohibition under clause 54 to grant the interest. Now, my lord, before that, if your lordship,
That point has been negated by the Section 34 court.
my lord,
That point has been negated by the Section 34 court.
a section 34 court says that, my lord, since the arbitrator did not, my lord, decide on the question whether 54 prohibits or not prohibits, and no reasoning has been given, my lord, while, my lord, granting the pre-suit interest and, my lord, pendentiality interest. So, my lord, arbitrator award, so far that pre-interest and, my lord, pendentiality interest is bad in law, my lord, and that has been set aside. Now, my lord, if your lordship kindly look into, my lord, the section 11 application which they have filed, my lord, where they have taken several, my lord, questions, where, my lord, the question of pendentiality interest, pre-award interest, and all other things were there in their petition. And that petition was replied by us in section 11. Now, my lord, ultimately, if your lordship looks into the order dated 14/9/2014 and all these two materials, my lord, it is very clear that the parties went to, my lord, arbitration only on the very specific four questions, my lord, not on the question of pendentiality interest, not on the question of pre-suit interest or anything, my lord. My lord, if your lordship kindly
No, maybe, but interest is granted incidental to the award. If the award was nil, nothing. But if the award is something, then interest follows. Now, what interest has followed? Pre-pendentility post.
Yes.
Now, what the Section 34 court has said? Post allowed. Pre and pendentility barred under clause 54.
Yes.
Right?
Yes.
Now, the question is that, number one, can clause 54 bar pendentility interest and
Pre-suit interest.
no, pre can.
Pre can, my lord.
Yes, pre and post, because that power is with the court, that power from the court is now with the arbitrator. And number two, even if it is held, yes, it is barred, whether you have waived it. If you are ready with your arguments, you can proceed, or you can do it some other day.
Some other day, my lord.
When?
Well, in fact, the matter is fixed tomorrow also. But I think, my lord, let it be taken up, my lord, sometime in the month of March, because, my lord, I told, my lord, earlier also that I'll be away in the month of February, my lord.
No, we will forget everything. What March? You can't do it next week.
Next week, no, not be possible. My lord, say it fixed tomorrow, my lord, also.
Today and tomorrow, so it will be concluded. In fact, that's why.
No, it can't be taken up tomorrow. It will be taken up sometime. You do it next week. Or you are here or not here?
My lord, I'll not be there, my lord. I'll be abroad, my lord. I am going on 16th, my lord. On the last occasion, while my lord fixed it, my lord said that all right, we are fixing it on 13th and 14th. And his argument is already concluded, so you start your argument. Today, my lord, he started afresh.
No, when will you be back?
হ্যাঁ 11-12 করুন নাকি 11-12 মার্চ 5th of March হ্যাঁ 5 তারিখে হলে কমপ্लीट করবো না 4 को कैसे कहीं लगेगा क्या नहीं में नहीं 11, 12, well, can it be, my lord, not inconvenient to my lord, 12th of March and 13th of March, so that we can finish it, my lord.
Already.
13th is not holy. 14th is holy.
Please, don't. In every matter, this court is becoming worse than a arbitral tribunal.
My lord,
We will not. From next time, we will not allow this.
well,
If you start a matter, finish it day by day. This has become like an arbitral tribunal. Not your matter, in every matter. People are taking out diaries, exchanging dates. All right, 12th and 13th. So we will have to make amends next week. This court cannot function in this way. Either you leave aside matters and come here, or you don't do it. 12th and 13th. Learned counsel for the appellant, please give his full name. Concludes his arguments. List this appeal for further hearing on 12th and 13th, March 2025. Can it be 11th and 12th March? 11th and 12th March.
my lord, 11th I'll not be there. My
Why?
lord, I have some other matters fixed, my lord.
No, where have you fixed your matter?
In the High Court, Guwahati High Court.
Before single judge or division bench?
My lord, it is before, my lord, single judge, my lord.
Then you have to give division bench priority.
No, definitely, my lord. I'm not saying it.
Because again, 13th is before a long weekend.
14, 15, 16, 17.
Yes.
Or, my lord, thereafter, your lordship can fix together, my lord.
No, we will forget everything. 12th and 13th.
All right.
We will see what can be done. 12th and 13th. Huh? You please bring your notes. For to hear the respondents. This is what is happening in this court. I'm noticing. It is being argued for some time, and then 1 month's adjournment, 2 months adjournment. What remains of the matter? Nothing.
I know, my lord, I understand.
When it starts, it has to finish. Short adjournments, okay, but not this long. This is done before arbitrators. It is not directed at you, sir. It is general. In each and every matter it is
Well,
happening.
I understand, my lord. It's not
In
that.
each and every hearing matter this is happening. And this kind of thing happens in Calcutta High Court Circuit Bench in Port Blair. Nothing is concluded. One matter is heard for half an hour, then it is adjourned for 2 months. Thank you.
Item number 1.
Have you done it? Who's appealing for respondent number 5? Have you filed an affidavit of service? Received. Who is respondent number 5?
Is the village council.
An affidavit of service is on record. None appears for the respondent number 5. List this appeal once again on February. Paragraph.
I take of your indulgence, Your Lordship. Can it be after 24th of February, Your Lordship? Can it be after 24th?
On 24th?
Any day after 24th, Your Lordship.
Because there are 3-4 very heavy matters fixed.
Personal difficulties still up to 24th. Any day after 24th, Your Lordship. Any day after 24th.
On 3rd March, advocate on record for the appellant will serve a notice upon the respondent number 5 that if none represents the respondent on that day, the appeal will be decided ex parte. Against the party. The matter will be decided ex parte. That will.
Item number 2.
Yes.
So I think not think better. So finally,
On the prayer of learned advocate for the appellant, this appeal is adjourned till 24th February.
Item number 3.
Yes.
In this case, respondents is family respondent. Spouse is suffering from serious kidney failure from 2021. Reimbursement of OPT bills was held up as he was taking his medical allowances on that count. So CAT has directed to reimburse the OPT bills, stopping the his medical allowances. He has already applied for that long back in 2010-2020. So I'll pass just this operative part of the CAT order.
You're the petitioner.
Here what happened, the respondent was submitting NCA, Indian Council of Legislatures, Shillong. They retired from service and he opted for They are governed by CCS medical attendance rule for reimbursement of medical bills. Now, under that level, there are two schemes. One is called fixed medical allowance scheme system, and other is without fixed medical allowance. So now the company provide matter if somebody is availing fixed medical allowance. In that case, fixed medical allowance will be treated as OPD bills. So it will not be entitled to OPD bills. It will only be entitled to inpatient IPD bills for reimbursement. For those who are not availing fixed medical allowance, they are entitled to both IPD reimbursement as well as OPD.
So what is the difference between OPD and IPD?
OPD is when outpatient.
Okay.
Visited doctor.
And IPD is on admission. So this patient will, this according to the terms of service was entitled to OPD.
In terms of rule, he had not such choice. Either he could opt for fixed medical allowance or without fixed medical allowance. He opted for fixed medical allowance. And under that, every month he received 1,000 rupees as fixed medical allowance. Now the rule says that if somebody is availing fixed medical allowance, he will not be entitled to OPD bills. Because it is assumed that 1,000 will take care of the OPD bills.
Is a dialysis special matter. Special approval was accorded by the director at page 60 of the petition matter. Approval of complaint authority ICF union is hereby accorded to Superstreet.
The bills in question are OPD bills. How much? What is the amount?
Amount is a recurring matter.
But the employee is entitled to IPD.
This is only entitled because he is availing fixed medical allowance per month.
But I have applied for withdrawal of this long back. That was kept pending. Not yet decided.
So when a patient is undergoing dialysis,
dialysis matter.
how many hours are consumed in the hospital?
6 hours. 6 hours it is consuming the hospital.
So if you take a human view, this time spent in hospital for dialysis, OPD is short duration. You show a doctor, come out. So whether it is possible to treat that as IPD. All you have to do is to treat that as IPD, admission.
My lord, he is very much aware. I can just
So
complete.
you should not in such a case take such a rigid procedural.
What we are saying, my lord, the rules also provide that he can still, in his lifetime, there is a provision for changing the scheme, my lord. So instead of doing that,
Under the scheme,
my lord,
all you have to do is to treat the patient as admitted.
Yes, ma'am.
my lord, the difficulty, the rule
You
is
think about it, we will take it up on Monday.
Monday, my lord.
You also think about it.
Monday, my lord.
Yes.
Monday, 18th, I will be informed.
17th is Monday.
17th.
Sorry, no.
No.
17th.
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 Yes.
No, no, 17 I will go to inform. 20 you can fix me. Is at the inform board. So 19 I am coming back. 20.
After hearing learned counsel for the parties, hearing of this application, further hearing of this application is fixed on 20 February 2025.
Much obliged.
Think about it, Mr. Monika, because
My lord, I discussed with the department. They are saying that
they will not understand. You have to persuade them.
No, but I tried to
They are rigid, rule-oriented, and they don't have that broadness of mind to how to apply the rules.
But what we suggested to them also, that even now, because rules provide for once in a lifetime, they can change the scheme, my lord. Instead of doing that, my lord, he can file an application now also that he want to opt out of fixed medical allowance, and then he will be entitled.
We have already submitted my
We are doing that, my lord.
withdrawal.
But then they will not get the back benefit.
My lord, that will also may consider, my lord, on humanitarian, subject to lordship. But he
So
should,
that we will direct that
he should follow the rules also, my lord.
you will transfer him to that scheme. We can direct them.
My lord.
The process is application and transfer him.
My lord.
And as far as
No,
the
my lord, if the client is here, my lord, he will explain, my
What
lord.
is there to fight about that?
don't call the client like that.
Kindly.
Then why are you appearing? Don't do this like a film.
My lord.
Yes.
Deeply-